Next time I moderate a panel, I'll be tripping on acid. Thank you very much for that introduction. So, actually, my wife is in here. I'm just kidding, sweetie. I will say thank you to everyone for being here. And before we begin this panel, I also want to thank George Mason, Law and Economics Center, Matthew and Donald, everyone here. I mean, this has just been an amazing conference, and I hope everyone got a lot out of this. And I know this is the last panel, but thank you, Matthew. Thank you, Donald. Thank you for everything you guys did. Thank you. And I must admit that I do feel a little bit like Larry Fortensky on his wedding night. I don't know if you know who Larry Fortensky was, but that was Elizabeth Taylor's 7th and final husband. And so on his wedding night, he must have been sitting there saying, well, it's all been said and done. What can I do that's new? So not the kind of jokes you normally hear in Tennessee. But anyway, I do want to thank everyone for being here. The panel today is entitled Motivations of Settlements, Especially with Public Entities. As Attorney General, myself and many of my colleagues, consumer protection has always been a big focus of our offices, whether Democrat or Republican, because very often we are the last place folks can go when it comes to consumer issues. But one of the things that our office has tried to do is to make sure when there are consumer-related lawsuits, that litigation focuses on making sure that consumers get the restitution and consumers are actually protected versus creating opportunities for one government entity to try to micromanage the private sector. So I am very pleased to be moderating this panel and with some folks that know about this area a great deal. Our first panelist, Paul Nolette, is an associate professor and the chair of the Department of Political Science at Marquette University, the Klingler College of Arts and Sciences. He will be followed by Annie Donaldson Talley, a partner with Luther Strange and Associates. And the final panelist speaker will be Christopher Seeger, a partner at Seeger and Weiss. So without any further ado, let's kick the tires and light the fires.
All right.
All you, Professor.
Great, thanks for those introductions. And I've really enjoyed this conference, learned a lot. So thanks all for being here. So a lot of the panels yesterday and into today as well, dug into areas like opioids and environmental litigation.
Time.
Nuisance.
No, I'm just kidding. All right.
Oh, no, I
just want to make sure everyone's paying attention. All right, okay.
So especially with this last panel, I was hoping to kind of pull back, give a sense of the big picture a little bit, and focus on what has changed with settlements with modern day public entities over time. So one thing that, if I can get this working here, one thing that political scientists love to do is count stuff. So one of the things that I've done when it comes to AGs is count really some of the multi-state activity that they've been engaged in, and that includes some of the multi-state settlements. So this shows you a little bit of over time multi-state settlements and how they've progressed. And what you can see, from 1980 through the present, and clearly they've increased over time, and especially after the tobacco litigation of the 1990s. It's sort of settled into the 20, 25 multi-state settlements a year recently. And I mention all of that because, a lot of the AGs in office now, AG staff, have been in their offices for a time where this is kind of like, this is the background. We expect multi-state litigation, but it's important to realize it is still relatively new. So a lot of the mechanics and dynamics here are still very much evolving. So multi-state collaboration settlements has increased over time, as you see. It's also become a lot more sophisticated over time. So numbers can help, right? They can give you a sense of the big picture, but in some ways it's also misleading because some of the later cases, especially the last decade or so, have been quite a bit more complex and involved and broad than some of those earlier cases. So a lot of those, late 1980s, 1990s, you see a little spike there, involved just a handful of AG offices. A lot of them dealt with cases alleging misleading labeling of consumer products, especially food. So for example, There were claims about Arby's promotion of its burgers and fries as being a lean meal, as being misleading. Also, another one challenging Kraft for advertising Cheese Whiz as real cheese was challenged. And I got to admit, by the way, that even though I'm from Wisconsin, I like Cheese Whiz. I mean, that's my daily confession. So of course now the stakes are a lot higher in these cases. Again, dealing with opioids, dealing with large-scale public health issues. And also the nature of the coalitions have changed as well. So, I don't have it up here, but if you look at the average number of AGs that were part of the suits early on, it was a lot of times groups of 6, maybe 8 AGs collaborating together. Now it's more than doubled in the cases since then. I think the median right now is like 21, but there are a lot more cases than there used to be that have half or more of the nation's AGs involved in these settlements. So, in some ways that could make negotiation of settlements more difficult, but there's also been a growth of institutional support for AGs to carry out this stuff, including the consistent use of working groups, executive committees that serve as the point for investigation and negotiation that have helped with kind of coordinate what is more complex and more involved litigation over time. So I think on the first panel, a number of people mentioned about the, thinking about settlements as how do we get the more efficient enterprise there, and we've seen that develop in the last few years as well. And one thing that I really want to emphasize, since there are so many AG staff in the room, is just how much the expertise and kind of quality buildup there's been in the last few years. I mean, with offices really building deep expertise in a number of different areas, that's really been a sea change since the earliest days of multi-state litigation. So, and sometimes that can be both informal, individual people building up expertise, or formally with like Massachusetts and New Jersey, Connecticut, other states creating things like consumer privacy and data security enforcement divisions. And of course, there's a lot of other examples of other divisions in AG offices that have developed over time as well. So in addition to this all becoming more sophisticated over time, the goals of these collaborations are broader. This has come up many times during this conference. And again, I think it's important to realize that, the money is always important in these things. There's a lot of it, and there's a lot of potential consumer restitution in these cases that has to be considered. But a lot of these litigation campaigns, especially following tobacco, has been about getting lasting change in industries. And these injunctive and regulatory provisions, I think, are a huge part of the end goal, much more so than even those earlier cases. So, one of the interesting ongoing issues now that I just put on the table is how to best establish, corporate monitoring provisions to achieve the goal of persistent future compliance with settlements. So, again, just to step back, I think one thing that's really changed in this litigation, even compared to the pre-tobacco and even immediately after, is that there's a real emphasis on how do we change corporate behavior so it doesn't come up again? How do we make these settlements stick? And so corporate monitoring, I think, is a hot topic now. I mean, the federal government has used corporate monitors for some time now, but it's been generally rarer in the states, usually connected with deferred prosecution agreements in the criminal context, but not as much in some of the contexts that we're seeing today with like the National Mortgage Settlement Agreement a few years back, and some of the settlements dealing with for-profit education and such. And it's interesting to me because that the moment of independent monitoring and corporate monitoring has arrived because, I think it was just a few years ago that independent monitors now have their own trade association. So, it's now an industry in and of itself. That includes a number of former AGs and AG staff. One other thing that I just mentioned about the dynamics of settlements, sort of the broader dynamics that has been true of a lot of this later stuff, has been the extent to which public entity settlements, and this came up in the last panel, how they've really spurred change throughout the American legal and political system, both by sometimes spurring states to adopt their own regulations or legislation, often of which AGs are involved in that process, on things like data privacy, and so adopting new laws and new regulations that kind of carry on the work that the AG really initiated. And also the potential for settlements to set some strong business precedents across industries, even those entities that weren't involved in the case at all. So, I mean, just to take one example of many, like the recent settlement between a number of AGs and the online retailer Cafe Press had a number of data security best practices built into the settlement, dealing with information security and data breach programs that the company was expected to implement. And you know, there's a lot of other companies now that are saying, well, we got to look at that if we want to avoid liability. And so even without active investigations or active litigation, this can have a real impact across the entire industry. The last sort of major point that I'll make is to mention, because this really is important, and it's important to me as somebody who teaches and researches in American politics, is just that this activity has remained bipartisan across party lines. AGs working on these multi-state settlements over time. I mean, the vast bulk of these displayed here are bipartisan. By contrast, certainly much of the rest of the political system, there's increased partisanship, polarization, distance between the parties, and amongst AGs, certainly we see that as well. I wasn't originally going to show these slides, but I thought you might be interested, and it was kind of sparked by the conversation by Attorneys General Gonzalez and Slattery yesterday when they talked about some of the tensions between the federal government and the states. Just to give you a sense, so I also track, in addition to the settlement, so multi-state litigation against the federal government. And just to give you a sense there, this is the picture. These are the number of multi-state settlements against federal defendants, the federal government over time from 1980 through the present. And you can see that it just, after kind of creeping up a little bit through the 2000s during the George W. Bush presidency and Obama, it just shot up completely. And one kind of amazing stat is that the number of multi-state lawsuits against Trump just in his 4 years was more than the 16 years of W. Bush and Obama. So, I mean, like, this activity has just gone through the roof. And it's almost entirely partisan, I should say. One other aspect of that, just another example, this is the percentage of multi-state US Supreme Court briefs that are filed by AGs of all one party. So either all Republicans, all Democrats filing these briefs. And as you can see, stayed relatively stable, but then in the last decade or so has just gone up to the point where 60 to 70% of these briefs are completely one-party briefs in front of the Supreme Court. Now that has, is not directly related with this topic of settlements and the public entity litigation in that sense, but I think it's interesting that on the one hand you have this affirmative litigation against corporations that stayed resolutely bipartisan, and this other piece that has gotten more and more partisan over time. So in some ways, I just want to emphasize the point again, like how important this is, that this has stayed bipartisan and gets these important conversations about consumer welfare and such across party lines. So just very last thoughts in the closing minute here that I'd mention is that there are a few interesting counter trends that kind of link in with some of the dynamics and mechanics of the settlements with public entities. One has been talked about, I think at some length, still remains, of course, very interesting and important, which is localities getting much more into the mix, like in the opioid investigations. But also how, perhaps this isn't something that I've necessarily tracked, quantitatively, but it does seem like there is more willingness for states occasionally to go their own way, even, parallel to a multi-state settlement. And we've seen a number of examples with Johnson & Johnson and Equifax and the T-Mobile Sprint merger review and other issues as well, where states are kind of splitting off from the main settlements. So that opens up some potential, issues and questions about how these dynamics will continue in the future. So I think with that, I will close with that sort of big picture and turn it over.
Annie, who's next?
Want to go now? So in the context of discussing settlements, I'm by no means an expert on representing public entities or political subdivisions. I was involved with the Volkswagen clean diesel case on the plaintiff side. We did work cooperatively with DOJ and other governmental entities, the California AG, to put together what I thought was a very successful settlement. And I would think it's a really good example of when private lawyers work with governmental entities, they can achieve pretty great things. And when I say pretty great things, it probably depends on what side of the V people are on in that one. Moving on to opioids, I'm also involved in opioids as one of the negotiators of the settlements that have been put together, along with others. I'm not by any means the only. So I thought it might be useful to kind of set the table a little bit about how I got involved with that. And one of the downsides of doing these 10-minute lead-off discussions is I might spend 10 minutes talking about something nobody's interested in. So I'll try to bring it in for a landing in less than 10 minutes so I can get to questions. But I live in New Jersey, and I have pretty good relationships with some of the attorneys that represent cities, counties. I know mayors. When this as you all may know, when the opioid litigation started 15, 20 years ago, it was initially brought as individuals suing for injuries they had sustained because they'd become addicted to prescription opioids. That litigation was wholly unsuccessful. Didn't really go anywhere for a lot of reasons. It's a pretty complicated situation. Many folks who get addicted to opioids are typically, I'm not going to say all, but a large percentage of them will start on a prescription drug and wind up dying and overdosing on fentanyl or heroin, something from the street, because it's a lot cheaper. When this cropped up, I was a little skeptical about it, but the thing that drew me into it is knowing mayors and county attorneys and folks who spend their lives working in government in New Jersey. They, and believe me, New Jersey is not a very schizophrenic state, not like others where you might have a Republican, governor and a Democratic legislature, where you've got all kinds of political tensions. But there was a concern that stemming from the tobacco litigation, that the counties, the mayors, the cities did not get their fair share of the dollars that came into the states. It went to the states. And this is the local person's view. And it went to building roads and other things, but didn't really go to dealing with the tobacco issue there. They didn't want that to happen, so they hired private attorneys like me, and the only charge I got for the most part was just make sure when the money comes in, if you guys settle, there is a mechanism to make sure it goes directly to the political subdivision. Why? Because some folks look at that and say, well, most of these political subdivisions get their budgets from the state. Why are they harmed and why is it not the state? But if you talk to a local mayor or a police chief or somebody who's running the hospitals, the police chief would say to you, 50% of the time my cops are injecting Narcan into the nose of heroin or opioid addicts when they should be out chasing bad guys. Or they're using their squad cars to put these people in the back of them to rush them to the hospital. And the hospital administrators have the same kind of story. And then the mayor says, well, our police are not policing the streets because they're dealing with this problem, people coming into our neighborhoods. So that's why the private attorneys got involved, and that's why I think opioids developed in a direction that was very different from tobacco and others. So now, to bring this in for a landing, you know, there are a lot of, I mean, I think you folks, I'm just flew in today, so I don't know how much people know about the settlements that are in place, but they are massive, massive settlements. I mean, it's litigation with extremely high risk. Yes, nuisance theories were used, but in addition to a nuisance theory, Judge Polster in the MDL sustained our RICO count. I know Judge Breyer in California threw the RICO count out. It wasn't just nuisance, but the nuisance claim is obviously very important, and plaintiffs' lawyers have learned from litigations where they were used successfully, like lead paint and others. So, you know, I guess, you know, and again, I'm walking into a discussion that's been going on for 2-3 days, but if you look at the numbers of these settlements, like the distributors are paying $21 billion, you know, so just break it down. You've got the manufacturers who are over-promoting the drug. The nuisance claim basically says the general public was affected because they over-promoted. They sent doctors to speakers bureaus. They told doctors that the drugs were not addictive when in fact they were. Many folks know about Purdue. Teva did the same thing. Endo did the same thing. How did the distributors get roped in? Well, we've got pretty strong evidence that suggests they violated the Controlled Substance Act. Where'd we get that evidence from? There's a database that tracks these sales. You can see that the distributors were not monitoring them themselves. So they're going into small neighborhoods with 10,000 people and they're shipping enough opioid product for 500,000 people. Why are the pharmacies involved? Well, because CVS on one street was filling someone's prescription, and then they'd go to the CVS 2 or 3 blocks away and fill it again. So there was a lot of bad conduct going on, in my view, and not enough monitoring, and that's why they all got roped in, and that's what resulted in a $21 billion settlement with the 3 largest distributors, and then another $5 billion from Johnson & Johnson. The Purdue bankruptcy, as folks know about, the family wound up contributing a little over $4 billion to get the advantages of the release that the bankruptcy could provide. And I know there's a lot of controversy over whether $4 billion was enough. I guess we estimate the assets from the transfer of the company to a public entity, and where that money will now go toward abatement, probably going to generate $2 or $3 billion. So many billions of dollars have been generated here. So is this something that companies ought to be concerned about? Yeah, they should be really concerned about it, particularly if you've got this kind of conduct going on. Volkswagen, where I started talking about, which was a great partnership between California AG, some of the other AGs throughout the country, the DOJ, and private attorneys, was a very different case, right? Volkswagen stepped up pretty much day one and said, yeah, we committed fraud, we've acknowledged it, we've investigated it, and we're ready to settle. This wasn't that kind of case. This was a case with a tremendous amount of risk and very high stakes. I mean, the MDL judge in this case has been mandamus 3 times. One was granted. And for the life of me, I can't remember exactly what it was. I think it had to do with some discovery rulings that he had granted. I'm just blanking on it. But you don't typically see a federal judge being mandamused, you know, 1 time, 2 times, 3 times. So anyway, I thought it would be useful to set the table in the way I did. I'm happy to answer any questions about this. As far as the name of our panel is Mechanics and Motivations of Settlement. I'll tell you, I've been involved in a lot of settlements. The NFL concussion settlement, I negotiated Vioxx, which was a pharmaceutical product. I didn't see a lot of different dynamics in the opioid litigation as far as what drives settlement. Risk always drives settlement. On the plaintiff side, what drives it is they think their claims are going to be thrown out. If those claims aren't thrown out, plaintiffs are emboldened. And on the defense side, I think they thought that they would be able to defend the nuisance claim. I think they felt very confident about the RICO claim, and they didn't do well on that in the MDL, although they have done better in other courts. Although the problem with an MDL from a plaintiff's or a defendant's perspective is all the federal litigation is basically in front of that one judge, so that judge's ruling is a pretty important event in the case, which is why on the defense side, on the corporate side, there's a lot of lobbying and money being spent to try to get these types of rulings from federal judges to be able to take an interlocutory appeal up to the circuit court, whereas you know in federal court you need a final judgment. So defendants have to wait around for a while. But so the motivations were not that different. Now, in terms of the mechanisms of how this settlement was structured, it was very complicated. Just a quick footnote, I don't know how I'm doing on time here, but as a negotiator on either side, you're always looking at the other side's problems and trying to figure out how you can solve them. Typically, the defendant says, I need global peace. Okay, we got to figure out how to get you to that. They need certainty, they need one price, and they need it to be done. One of the problems we ran up against early on in negotiating this was many of the defendants said to us, there are 2,500 political subdivisions who file cases in the MDL, but there are 30,000 political subdivisions throughout the country. How do we know you talk for them? So one of the ideas we came up with was this idea of trying to get Judge Polster to certify a negotiating class. So you're all probably familiar with class actions. This has never been done before. You know, there are plaintiff class actions, there are defendant class actions, there are all kinds of ways they've been used. They're used for litigation purposes. You can certify an issue. You can certify a settlement where certain requirements of the class action statute might be waived because of that. This one was to literally certify a class of 30,000 political subdivisions so they would be in one class, and that if 75% of them voted in favor of a settlement that was presented to them, the settlement could proceed. The concept was to put them all in one room, in effect, and to be in a position where you could say to a defendant, if you're prepared to settle, we can tell you we think we can get you to global peace, and we think we could get you to the point where we could say we're speaking for everybody. That particular negotiating class got certified in front of Judge Polster and then got reversed by the Sixth Circuit because the Sixth Circuit felt it wasn't sufficiently tethered to the rule. They felt we stepped too far outside the boundaries of what, I don't agree with this, but of what Rule 23 permitted. So I just threw a lot of stuff out at you guys. I'm going to wait for the questions to come back, and that's all I have to say. Annie, you're up.
Thank you. Thank you, Christopher. Annie?
Great. Thank you all. Thank you to the Law and Economics Center for putting this on, and to General Brnovich and my fellow co-panelists. I know I have the distinguished honor of being the last presenter in the last panel, so I'll start my 45 minutes of introductory remarks right now. Everybody's heard a lot about the issues with litigation in this area, and my initial remarks are going to start by overlapping with many of those themes. I'm then going to turn a little bit to some lessons from my time in the federal government and talk about some practices that I sincerely hope the states do not adopt from the federal government. I think Jesse started down this road a little bit in the last panel, and I'll follow that off. First, I want to talk a little bit about the unique role and duties of the state at the settlement stage. This all may sound a little lofty and idealistic, but when I was in the White House and in other positions, it was drilled into me that you always start with the Constitution, and then you know, in regulatory matters, you start with the Constitution, then you look at the statute, then you look at the regulation. And it's important to remember first principles, especially in the heat of battle, especially when you think you're out at the margins, especially when you think this is a unique situation and it demands action. You still have to remember the first principles. So the biggest thing for me to remember in all of this is the role of the Attorney General and the state in both the litigation and the settlement stage. And we've talked a little bit about some of the unique dynamics and the shift in dynamics when this goes from a private action between two private parties or between a class of private parties and a private defendant, and when a state becomes involved as a plaintiff in the case. And I agree with this. When the state brings a sovereign authority to bear against a defendant, it's fundamentally different in kind than an action just between private parties. The flip side is also vital. So one, it brings a lot more power to the plaintiff side of the V, but the other side is important. You've got to remember that as a state actor, as a state official, you work on behalf of both sides of the party in some ways. You have a sworn constitutional duty to uphold, and you have to keep that in the back of your mind because it's very easy to just become one versus another, who wins, who loses. The state as a sovereign authority in our republic owes a duty to both sides, both the victim and the accused, at every point in the process. And we just have to keep in mind these fundamental ideals of how this works and how getting involved fundamentally changes things. Think about due process. something that I don't know that I've heard the phrase due process a whole lot today. And again, this may sound lofty and idealistic, but it's important to remember first principles. This is one reason why there's such a concern about the use of novel legal theories and tactics in litigation and in settlement. It's because of the principle of due process and fair notice as to what the law is and what the expectations of regulated parties and everyone that lives in the Republic should be. So people should have some sort of fair notice of what their legal liability should be. This also means that the duties for lawyers are different between two private parties and those for representing the sovereign state. I don't know how it is in every state. I don't know if every office does this. One of the biggest things that we did on the first day of our jobs at the White House was we got sworn in. And we got sworn in a semi-public way. It wasn't just, hey, I'm going to sign this oath. It was actually taking an oath, and it was important to remind everybody that this isn't just your next job. You are actually representing the people, and you have an obligation under the Constitution. The job of the lawyer for the state is not necessarily just to maximize settlement dollars for their side or punitive effects for their side of the V. It's also to remember to do justice. It owes a duty to both sides. Consumer protection is vitally important. It is one of the biggest things that the state attorneys general do. They are law enforcement officials. They enforce the laws. And if businesses and organizations violate the laws, I don't think anybody would disagree that they should be held fully responsible for those violations. Law enforcement is key. But remember, when conducting an investigation on behalf of the state or bringing a lawsuit on behalf of the state is essentially exercising an inherently prosecutorial function. So the use of government power is coercive, and it's, again, fundamentally different than private on private litigation. And as Professor Fitzpatrick alluded to yesterday, sometimes this can create a situation where it's the worst of both worlds. A drive towards maximizing profit off of a lawsuit combined with the coercive power of the state and the possibility, just possibility, that there might be some bad political incentives or corruption opportunities all involved in what is going on. Remember, prosecutors who are actually out there prosecuting criminals still owe a duty to both sides, not just the victim, but the prosecuted. And if we expect that of people that are prosecuting murderers and rapists and terrible people who have done terrible things, we should also just remember that in other contexts. Good prosecutors don't just go to maximize the amount of years that somebody gets behind bars. They don't just try for the most convictions or the most plea deals. They try to aid in the administration of justice. And that's also one reason why there's such concern about turning the power of the state over to private attorneys without a number of safeguards. Sure, there are arguments about costs and about portion of the settlement and things like that. But the bigger issue that we have to keep in mind, and again, we have to keep this in mind, this isn't an outright proposal of a ban or anything like that, but we have to keep in mind and make sure that we structure these things, that if we have private attorneys at the helm of making major decisions about the case and in driving settlements to maximize recovery for their clients, especially when they've got all sorts of different clients in the same case, that we remember this and find safeguards to make sure that the states, when they're exercising their state power, are still trying to do justice and not just maximize a settlement and win the case. Again, this all may sound lofty and maybe a little idealistic, but it's so key to remember this in the heart of battle. The stakes in some ways are higher in the settlement context, where there's not a full refereed adversarial airing of each side's position. We talked a little bit about this in previous panels. We talked about how sometimes the settlements, since they aren't going through a judicial proceeding, they adopt new creative things that may not be part of the law. They may go well outside the law. Professor Nolette talked about how sometimes in these settlements you create you adopt new ways of doing compliance that are far in excess of what the legal obligations are. And this is especially true when novel legal liability theories are at play. Again, to analogize to the criminal prosecutor, some jurisdictions actually require prosecutors to turn over Brady evidence, not just for trial preparation, but also prior to plea deals. I'm not suggesting that this should be the rule in civil litigation, but there is logic to this. Jesse talked about the novel legal, the concern about novel legal liability theories expanding without the check of any sort of litigation or a courtroom to test these theories of legal liability. But just because a court or jury may never decide these issues, the state cannot remove its white hat. In fact, it's even more important that the state keeps it on in these contexts. For many, the process itself can be the penalty. We heard in a couple of presentations how individuals are sucked up into different situations where the state is coercive and they just can't get out of these situations and get resolution to their case. That happens on every level through these settlement negotiations. The pressure to settle is immense for global peace and to be able to move on in your business or your personal life or whatever context we're talking about. So again, the incentives must be different between the incentives when only private parties are litigating it against each other. Now, let me then turn to identify one additional cause for concern that we see a good bit in the federal government that I again, sincerely hope does not trickle down to the states. And that is the government using settlements to achieve policy outcomes and regulatory outcomes rather than the enforcement or redress of injury. This can happen through settlements. This can happen through consent decrees. This is when the state's on defense from plaintiffs that are seeking an extension of the law via the courts. This can also be in settlements in enforcement, where the state's on the prosecuting side of the V to expand the scope of the law past its outer boundaries. And this is a flip side of the previous concern. And the third is the use of third-party beneficiary in settlements. These things all are bad for the judiciary, and they're bad for the state. They're bad for the people. We need to keep these things in mind and hopefully keep them out of the state government. Admittedly, these are things that are set up to happen a little bit more on the federal side, especially with the unitary executive, but we do see it otherwise, and it is a common tactic in some circles. So, when we're talking about settlements, and not just in the big cases and the once in a lifetime or once in a generation cases, I'd challenge everybody in the room to just keep some things in mind. One, remember the power of the state. Remember the role of the state AG. When you're doing settlements, are the settlements compensating victims or redressing harm? Are the settlements connected to the allegations and the law from which you pursue the action? Who and what are third-party beneficiaries? What is their connection to the case? And why are they receiving any benefits through a global settlement? And I would especially be concerned about some of the practices of the federal government on third-party payments being picked up on the state level. Jesse talked about a little bit of these an hour ago, but these third-party payments are very concerning. They don't go to the victims or mitigation. They lack transparency and accountability. There's a possibility of self-dealing, whether it's politically, ideologically, or otherwise. And there are many other concerns with these third-party payments that I am going to save for any questions that anybody has about them.
Thank you very much. Thank you to all the panelists. Does anybody want to very quickly respond a minute or two before we have a bunch of questions here? Whoever this anonymous person is keeps asking stuff. So
There's a couple of really good points I thought that Andy raised, and I don't know if I'm misinterpreting them, but you know, on the issue of where private attorneys get involved and they're representing political subdivisions, you know, private attorneys have also been hired to represent AGs. I agree with you that that's something I think people have to keep an eye on, and I'll tell you something that I'm a little concerned about from a plaintiff's perspective is seeing plaintiff's lawyers representing political subdivisions and AGs. And I've seen that. I'm not going to call people out on it or what cases, but I've seen it, and I have some concerns about conflicts that are inherent in that. That not necessarily the point that you were making, but I just thought it was worth bringing up. But on the settlement side about, pushing these regulated entities to the point beyond what the regulations require, that's not really a new concept. I mean, the SEC regulates securities trades, yet there's private enforcement of the securities laws, and the environmental department, environmental laws are usually used as a predicate act for plaintiffs' lawyers to sue. So I'm not sure I see any real concern or harm with that, other than I think that your concern is whether there'd be some kind of, I would like to understand that better, I guess.
Yeah, I think when it's the government who is seeking these things, at least on the federal level, I don't see this as much in the state, but on the federal level, I see a lot of times there's a lot of areas where I've heard conversations and been involved in decisions where it says, we don't have regulatory authority here, but we're going to push past that regulatory authority in the settlement context and try to settle these cases for much more than we actually have the power to do. So I think, that, again, this is different between the private party situation and when the government actors know they don't have the power and authority to do something and seek it out through settlement nonetheless, especially in the federal context where they've got so much power over entire industries that they can basically, if they enforce against one company or industry, one player in the industry, they know the rest of the industry is going to have to adopt this for fear of becoming next in the eye of Sauron through the regulators. So I think this is touching on your point there, that when it is the government and they do have limited authorities, you've got to be careful against this.
So an interesting, I'm sorry, can I take that
no,
one?
you sound like a plaintiff's lawyer. You don't get the last word. I'm just kidding. That's a joke. No, go ahead. I give you 1 minute. We got to get on to the questions.
I was just fascinated by that because what I've observed again, going back to the Volkswagen clean diesel situation is, DOJ, I mean, obviously it was wrong of Volkswagen to lie about their emissions. They said their diesel technology didn't pollute. DOJ jumped all over them. DOJ jumped all over Mercedes, but has done virtually nothing with regard to other, I believe, corporate wrongdoers. And I'm just, I don't.
That happens too?
Yeah. Anyway, sorry, Attorney General.
No. Don't be sorry. It's all good. Anyway, so one of the questions is, feel free, everyone, to weigh in. What is the best approach to overcoming tension between the state's attorneys general and private counsel in litigating these high-stake cases? Does anybody have any thoughts on that? How to approach the tension in these cases?
I mean, quickly, there's obviously I think that at the end of the day in the opioid litigation, the states and the private lawyers worked very well together, but tension the whole time. When the initial settlement was announced of the distributor settlement was initially $18 billion over 18 years. Private lawyers, we rejected that. Some AGs bought into it, some didn't. So, and we ultimately, I think what improved the settlement was that many AGs that didn't buy onto that one continued to push with us. I think we were able to harmonize our approach with the attorneys general to get the result we did, which is ultimately it's a $26 billion settlement. So, I've seen the tensions. I've also seen really skilled people in the AG side and the private lawyers work through those tensions in a way so that they tried not to step on each other's toes. Obviously, we were less involved in the injunctive relief that the AGs wanted because they had the ability to enforce those better than we, the injunctive components better than we could. But I can definitely see a case that hasn't come up yet where that tension would be a problem.
Anybody else? Any other thoughts?
I'll just say that from my perspective, I think there are two main things. One is addressing the conflicts. When the state is represented by somebody who also represents political subdivisions and or even private parties, those are conflicts that are almost impossible to solve. And the second is control. If the state is going to allow a private attorney to exercise its power on its behalf, it has to be able to rein in and control the private attorney. It has to be able to have some measure of control over what the case is going to argue, what the sought after remedies are going to be. And I know that's very difficult in especially these huge MDLs. But I think those are two of the main things that you have to solve on the front end, because it's certainly going to come up at some point in time in the litigation, and afterwards is too late to solve these problems and keep some of these role of the Attorney General type things in mind.
Paul, anything? No?
Well, just to say that, kind of going back to, in fact, Professor Fitzpatrick's point about class actions and from yesterday is, I mean, it is important to realize that there are two different goals here, oftentimes, between the private attorneys and who might be maximizing the monetary provisions, but then the injunctive relief from the public side. And I think it's inevitable that you're going to have those tensions, but it's also a reason why I think those two things can complement each other, and even if there are tensions. Yeah.
Well, while you got the floor, there's one of the questions are there certain states that lead in SCOTUS AG filings? Or do certain states exert more influence? Ignore that I'm sitting next to you. Okay, good.
So Arizona.
Oh, that's right. Right answer. Right, you are there, Professor.
Arizona's
Yes.
briefs are amazing, by the way, just incredible. But yeah, so there are in all of this multi-state litigation, including the amicus briefs, as well as the settlements and the litigation directly against the federal government. You see some leaders emerge there. Certainly, Texas is one of the top filers of amicus briefs in the Supreme Court, and then on the typically Democratic side, New York, California. So really, these bigger offices you see really kind of leading some of this charge. But even a number of the smaller offices, and this gets to that point about AG staff just being so much more sophisticated than even 2 decades, 3 decades ago, is that you have smaller states and smaller offices that also build up expertise in ways that they often are leading the New Yorks and Californias and Texas as well. And I think that's a real testament, I think, to the fact that AGs have become much more important players on not just the state level, but the national level as well, and including really building up their U.S. Supreme Court practice through Solicitors General and other instruments of really improving the quality of briefs. So,
if state laws on public nuisance differ so much, how can they be resolved in an MDL? Anybody?
I'm not sure I understand the question, because so in the cases that have been teed up for trial, the court has made an election as to what law will apply.
Yeah.
And I don't know, frankly, I just can't remember right now if Judge Polster has made a determination that some states' nuisance law just cannot apply. So my guess is that what happened is they went through a bellwether process where the candidates for cases that could be tried had nuisance laws that he could then decide would apply and move forward with their trial. I just had not spent a lot of time thinking about it.
Anybody else? Any thoughts on that? All right. How do states fund developing multi-state expertise and fund the cost of these sophisticated lawsuits? What would be, how do the states do that? Anybody?
Well, and I'll start by, part of it is, as we've been talking about, kind of tapping expertise in the private bar as well for some of this stuff. I mean, that was certainly big in the pharmaceutical, like average wholesale price litigation and all this highly complex stuff. But I think that is an issue that came up yesterday too, that I think is just an important one to think about. Is there's a lot of diversity amongst the states about where money goes after settlements. Some states it gets sort of dumped into just the general fund. Some there's a revolving fund. Some the AGs have more control over where the money goes, and and that really makes a difference. It's hard to give a answer, across all jurisdictions. But I think those areas where some of the money can go back into consumer protection practices can help. I mean, that can help maintain and expand the resources that AGs have here. But just thinking about the staff again, I remember I think it was back in the 1970s, so going back a while now, but even when it came to like Supreme Court practice, the US Supreme Court was scolding states a lot, saying, you got to step up your game, basically. And state AG offices have taken that advice, both in the amicus brief aspect, but in a whole range of areas to really build up that expertise. Some of that comes from additional funding from states and the federal government, but some of it has come from settlements over time. And so I do have some concern that if too much of that money gets diverted away from AG offices, then that's going to, it's going to potentially hurt.
I just wonder what everyone's thoughts are related to that, is that there are AG offices with an emphasis on making sure consumers get restitution, and other settlements, AG's offices want to make sure that the money does go to either consumer protection and it doesn't go to the general fund. Because is there some sort of, if the AG is essentially acting as a plaintiff's lawyer and trying to get money to the general fund, does that create perverse incentives for the states as well? I don't know if anyone has any thoughts on that, how that all plays out, and whether they should or shouldn't be doing that in settlements, or.
Well, I mean, just on the first point before I get to that, I mean, just to, again, since everyone's focused on opioids, the private plaintiff's bar put about $100 million in cash into litigating that case. And, some AGs had filed lawsuits, and I'm sure they put tons of resources into it, many of the political subdivisions. Actually, there were all kinds of things going on. But I think it'd be hard to deny that without that, injection of that kind of capital into a case where experts need to be paid, databases need to be reviewed and scrutinized, and it would have been more difficult to get the result. On the other part about the perverse incentives, I mean, I'm not sure I have a really strong opinion on that. I mean, I don't have an issue with the fact that the AGs are bringing cases to get restitution for consumers, compensation, cash, whatever it is. I'm not that familiar with that many cases where that's been done. I've seen that on the federal level, like the FTC will bring those kinds of claims. More on the consumer side, I haven't seen that much with the AG's office. So I don't really know. Annie?
I'll just say that, again, we're thinking about this from a private litigation perspective and how to develop a case and all that stuff. Let's not forget that the states do have some resources and powers that private plaintiffs don't have on the front end, like CID authority. They can start an investigation and build a case in a different way than a private plaintiff is able to. So, again, this is one of these things that you've got a square peg and round hole type issue, and you've got to ask the right question, which is, does the state have the ability, either through its authorities on issuing CIDs and conducting investigations, staff time, things like that, and then, of course, some money out of pocket for experts and other development. Asking if they've just got $100 million up front to develop a case the way that the private bar would is not the right question to ask. So I do think that joining together and doing a multi-state investigation allows states to work together and have more resources to develop the cases the way that they have authority to develop them. So there is that ability. I will say that one of the issues always on restitution and money coming back into the state coffers is, where does it go? It's one of the concerns about third-party payments. It's also one of the concerns about money just going back in the general fund and getting expanded or expended in ways that have nothing to do with the harm or with the reason that the money is coming in. I do think that's a big problem. And it creates other problems down the road on the state and federal level on earmarking funds and other things. Obviously, we'll let the separation of powers people argue about that. That's not for us to say.
It seems like there are different ethical considerations when an attorney is representing the public interest regarding settlement options. Is there a conflict of interest? I know we touched on this a little bit, but this question was asked. So does anybody else, or any thoughts on the ethical consideration representing the public interest in settlements and the conflict of interest? I know we touched a little bit about the city versus state, but any more thoughts on that issue, anybody?
My answer is just yes, there is an issue. I think you guys know where I stand on it.
I don't know that there's an issue, but Annie's brought up something that I do agree with. I mean, if the AG is going to hire outside counsel, there needs to be control asserted over the outside counsel. I have seen instances in certain states where they've hired an outside counsel and that person's role is I'm not sure they were playing a role that was really the role intended by the AG. So I think supervision at that point is critical.
In the MDL settlement negotiations, what innovative tools are MDL judges using to try to get states and localities to cooperate instead of compete with each other? And I guess the corollary to that, is that the judge's role, or is that up to the AGs and whoever they're dealing with to figure that out?
On the MDL side, that's probably more judge, if we're talking opioids, that would be Judge Polster. In any MDL, it would be the judge. And the techniques that judges employ, I could, quickly, in any MDL will be pressing discovery, establishing bellwether trials so that information, you can have cases that, like even in the opioid MDL, cases have been scheduled for trial. Now they've settled before verdict, but you still get very valuable information that will inform settlement discussions that come from, motions to, to summary judgment motions, Daubert motions, and the pretrial rulings on what evidence might be used at trial. So those are kind of the techniques any MDL judge would employ, and it really wasn't that different in the opioid litigation.
I'll just add, I think this is one of the issues with settling massive disputes on policy levels and everything like that at courts and in MDLs, because judges can only do so much. I think you listed some of the things that they can do. That doesn't necessarily solve the problem, whether it's opioids or climate change or whatnot, of how do we actually get resolution here when the law is kind of fuzzy and the parties all want different things and everybody wants their bite of the pie. So I do think that that's one of the issues that's creating this crunch in our tort system and our legal system, is asking judges to do much more than they have, than they're equipped to do in some of these instances, and putting them in really tough situations, making them get creative. And while creativity is important sometimes, it's also a little scary when you're thinking about trying to keep things rooted in the law.
I don't know if this was mentioned, but day one of the very first MDL hearing with Judge Polster, the very first thing he said is, I have no idea why this case is here. Like he did question whether, why is this on a federal judge's desk and not in Congress or somewhere else? I mean, he asked that question being dealt with, but he said, it's here, I got to deal with it, so let's move forward.
Yeah, and just kind of building off Andy's point too, I mean, when you get all additional information, trials coming up and all of this, and you have pressures to settle, and it is all about a number, then that can be tricky negotiations, but in some ways it becomes so much more complex when you're not just coming to a shared number that people can walk away and feel okay about, but when you're trying to balance policy concerns that don't really, in many ways, can't even be compromised. It's like, what are you putting emphasis on? What aspect of the costs and benefits are you emphasizing? And when having one judge and trying to manage all of that is, who's not, a policymaker or an administrator in the sense of a bureaucracy or something, is really difficult.
Congress can't even figure this out. How do you expect one judge to figure it out?
Well, I think you're all missing the most important point. Someone has a lot of familiarity with federal judges, that what is the difference between God and a federal judge? God doesn't think he's a federal judge. So, sorry, is my wife still here? Sorry about that. Hopefully she left already. And really, we are, no one wants to hear my jokes right now. What can courts do to prevent collusive litigation and settlements? Very quickly.
I'm happy to take that one because that's a talking point right from Beth Birch's book. I'm not even sure what that means. What's a collusive settlement? I mean, I'm not asking you, Attorney General, but I hear this all the time, and it doesn't make any sense to me. So the theory in Beth Birch's book is that defense lawyers and plaintiffs' lawyers are in a back room cooking up how to do these settlements, and then they come out of it with a settlement they agree to, and there's some way to coerce everybody to take it. That is a fundamental misunderstanding of how this thing works. And if there are defense lawyers in this room, I'm sure that on that one, we can agree that we don't go in a back room and pat each other on the back, smoke cigars, and figure out ways to spend your client's money and then force everybody into the settlement. So I don't know who asked that, but happy to debate that issue anytime.
Anybody else? Any thoughts? Call again. In light of comments, including statutory authority to come to terms, should judges sua sponte inquire? And I'm so sorry, because this iPad something came up and I can't read this question. But it's something about, should judges sua sponte inquire about the terms and about and related to statutory authority to the state to even enter these settlements? Thoughts, comments? Should judges on their own make that inquiry about whether the state has the ability to settle these cases or be involved in this type of litigation?
Yeah, I mean, I guess I would just say that, and this has come up before too, that states are and state AGs are the chief legal officer of the states, and since states have sovereign authority, I don't know how much, if I'm understanding the question right, how much federal judges should necessarily be the ones kind of getting in the middle of that. I do think to some degree, if there's concerns about settlement abuse, so maybe some of the, what Annie was talking about, some policy regulatory aspects of settlements, then perhaps it's, Congress, I guess, that we call upon to get involved, although how realistic is that, I don't know.
Good luck.
As opposed to, Congress as opposed to judges.
I think depending on how you take this question, I think those are the sorts of things that probably should be taken care of in motions, practice, and things like that well before a settlement hits, so that both parties at least know what the outer bounds of people's authority and what the law is. Those talking about ways to encourage a settlement, making a decision about what the law actually is, what the outer bounds of the law actually or the liability actually is, can help on that front. So if you take the question in that direction, I guess that would be my answer is let's actually get some of the answers done up front so everybody at least knows. This goes back to the Brady evidence and the prosecutor analogy. Let's at least know what the common understanding of the law for this case is going to be.
Why can't congressional inaction be considered a choice not to legislate on a topic? So should congressional inaction about doing something essentially be considered in essence an action? If I understand this question, you can read it, Professor. You get these questions like this all the time, I'm sure. I would say that my first reaction to this is that any fans of the band Rush will understand that if you choose not to decide, you still have made a choice. Indeed, go ahead. Apparently no Rush fans here. Okay, go ahead.
No, but I do think that, this has been a justification for a lot of what AGs have done, both in terms of suing the federal government, thinking about like Mass versus EPA and environmental suits like that, saying the EPA wasn't acting, as well as kind of filling the gaps. You hear that quite a bit of, hey, the federal government isn't taking aggressive enough antitrust enforcement, so we're gonna fill in those gaps. And it's interesting because if you characterize it, and maybe this is what the question's getting to, if you characterize it as filling in the gaps, then it's like, well, there's just nobody there that is even doing anything. But if there's a considered judgment to say, no, actually we don't want to regulate here, or we don't want to have regulation in this area, and then states step in and then start doing that, that's a different thing. Then you're kind of interfering with a considered regulatory judgment elsewhere by like an expert agency.
Yeah. It's one of the reasons legislative history is really tough. I mean, how can you impute anything on what, for example, Congress is doing for the last 2 weeks? What is Congress, so is it intentional inaction? Is it, there's so much of Congress is kind of inscrutable at this point. I say that as a law partner of a former senator who also left the room, so I guess I'm free to say that. Yeah. But
well, Washington, D.C. is where the good ideas go to die. So just,
But I agree. I think it's all a matter of framing, and Congress, who can fix that?
Congress.
No, they can't fix it.
Well, I do appreciate everyone's attention. This was the last panel, and I think that we're maybe a few minutes ahead of schedule. That's a good thing. So anybody that was in the military, the Army, understands the Ranger rule, that you never ask questions with 10 minutes or less, or else you have to buy drinks. And since I'm a fiscal conservative, no more questions. We're done. Thank you.